federal bailiffs physically removed Donald Trump's attorneys from a courtroom after they accused the presiding judge of running a kangaroo court and refused direct orders to sit down. This wasn't a routine objection that got heated. This was a complete breakdown of courtroom decorum that ended with licensed attorneys being escorted out by armed court officers while still shouting objections. Judge Sarah Martinez had given Trump's legal team multiple warnings. She had patiently explained her rulings. She had offered them a final opportunity to apologize and continue. They refused. Instead, lead attorney Todd Blackburn and co-counsel Jennifer Walsh continued their tirade, forcing the judge to order their immediate removal. When federal judges reach the point of physically ejecting attorneys from proceedings, it signals something has gone catastrophically wrong. And what happened in that courtroom reveals everything about Trump's legal strategy, the lawyers willing to execute it, and the professional consequences of crossing lines that should never be crossed.
This confrontation didn't emerge from nowhere. It was the culmination of weeks of escalating tension between Trump's defense team and Judge Martinez. The case itself involves federal charges related to obstruction of justice and conspiracy. Trump's attorneys have pursued an aggressive strategy built on delays, procedural challenges, and relentless boundary pushing. Every unfavorable ruling is framed as bias. Every piece of excluded evidence becomes proof of persecution. Every setback is treated as justification for escalation rather than compliance. Judge Sarah Martinez is a Reagan appointee with 23 years on the federal bench. She has a reputation for patience with attorneys, strict adherence to procedural rules, and zero tolerance for disrespect toward the court. Over her career, she has presided over organized crime trials, terrorism cases, and complex white-collar prosecutions. She has dealt with difficult lawyers, emotional defendants, and high-pressure situations. But what happened on January 15, 2026, was unprecedented even by her standards. The specific issue that triggered the final confrontation involved evidence that Judge Martinez had ruled inadmissible during pretrial motions. The evidence in question was a series of communications that Trump's team wanted to introduce to support their claim of selective prosecution. The judge had reviewed the materials in camera, meaning privately in her chambers, and determined they were not relevant to the charges, improperly obtained, and therefore inadmissible under federal rules of evidence.
Trump's attorneys had challenged that ruling. They filed a motion for reconsideration. The judge denied it. They appealed to the circuit court. The appellate panel affirmed Judge Martinez's decision. The issue was legally resolved. The evidence would not be admitted. Under any reasonable interpretation of courtroom procedure, that should have ended the matter. But during the January 15th hearing, lead attorney Todd Blackburn attempted to introduce the excluded evidence anyway. He rephrased questions to witnesses in ways designed to elicit testimony about the materials without directly referencing them. It was a transparent attempt to circumvent the judge's ruling through linguistic maneuvering. The prosecution objected immediately. Judge Martinez sustained the objection without hesitation. She reminded Blackburn that the evidence had been ruled inadmissible and that he was not to reference it directly or indirectly. Blackburn acknowledged the ruling but continued pressing. Within minutes, he made another attempt to bring up the excluded materials from a different angle. Judge Martinez called both legal teams to the bench for a sidebar conference. According to courtroom observers, her tone during that sidebar was sharp. She warned Blackburn that any further attempts to introduce inadmissible evidence would result in sanctions. Blackburn returned to the defense table and, remarkably, tried yet again within the next 10 minutes. At that point, Judge Martinez had reached her limit. She called a recess and issued a written warning from the bench. The warning stated clearly that the evidence was inadmissible, that the issue had been litigated and resolved, and that any further attempts would be treated as contempt of court. She asked Blackburn directly whether he understood, He said he did. The hearing resumed.
Less than 20 minutes after the written warning, Blackburn made his fourth attempt. This time, the effort was so obvious that even casual observers recognized what he was doing. He asked a witness a question that could only be answered by referencing the excluded evidence. The prosecution objected before the witness could respond. Judge Martinez sustained the objection and turned her attention to Blackburn. "Mr. Blackburn," she said, her voice carrying unmistakable authority, "I have now sustained objections to this line of questioning 4 times. I have explained to you in sidebar that this evidence is inadmissible. I have issued a written warning, and yet you persist. Why?" Blackburn stood at the defense table. What he should have done was apologize, acknowledge the ruling, and move to a different line of questioning. What he did instead was argue, "Your Honor, with respect, this evidence is directly relevant to my client's defense. Excluding it violates his constitutional right to present a complete defense." Judge Martinez's expression hardened. "Mr. Blackburn, we have already litigated this issue. I ruled the evidence inadmissible. The appellate court affirmed my ruling. The matter is closed. I am directing you to move to your next question." Blackburn should have complied. Instead, he raised his voice. "Your Honor, this is precisely the kind of ruling that makes it impossible for my client to receive a fair trial. We are being prevented from presenting evidence that would demonstrate—" "Mr. Blackburn," Judge Martinez interrupted, her voice sharp as a blade. "You are not to argue rulings that have already been decided. I am directing you to proceed to your next line of questioning. Do you understand?" There was a moment of absolute silence in the courtroom. Everyone present recognized they were witnessing a critical juncture. Blackburn could comply, and the hearing would continue. Or he could escalate, and something unprecedented would happen. He escalated.
"Your Honor," Blackburn said, his voice rising, "what I understand is that this court has systematically excluded every piece of evidence that might help my client, while allowing the prosecution to present whatever they want. That's not justice. That's a kangaroo court." The room went completely silent. Prosecutors leaned forward. Court staff exchanged glances. Reporters in the gallery stopped taking notes and simply stared. Blackburn had just accused a federal judge of running a kangaroo court in open proceedings. There is no ambiguity about what happens next when an attorney crosses that line. Judge Martinez's demeanor shifted instantly. The patience she had maintained through hours of objections and sidebar conferences disappeared. She looked directly at Blackburn with an expression of unmistakable severity. "Mr. Blackburn, did you just accuse this court of being a kangaroo court?" Blackburn, astonishingly, did not retreat. "Your Honor, I'm simply stating what is obvious to anyone observing these proceedings. The systematic exclusion of defense evidence while admitting prosecution evidence creates a fundamentally unfair—" "Stop talking," Judge Martinez commanded. "Mr. Blackburn, you have just committed contempt of court. You will sit down immediately, or I will have you removed." At that point, co-counsel Jennifer Walsh stood up. In any normal situation, the second attorney would attempt to de-escalate, apologize on behalf of the defense team, and salvage the situation. Walsh did the opposite. She joined the confrontation. "Your Honor," Walsh said, her voice loud enough to be heard throughout the courtroom, "the defense has an obligation to make a record of judicial bias. What we are witnessing is a clear violation of my client's constitutional rights, and we will not be silenced." Judge Martinez turned her attention to Walsh. "Ms. Walsh, you will sit down immediately. This court has been more than patient with your legal team's behavior. That patience has ended." Walsh did not sit down. Instead, she began citing case law, her voice growing louder. Brady v. Maryland establishes that the prosecution must disclose exculpatory evidence. By excluding evidence that demonstrates selective prosecution, this court is violating. Ms. Walsh, Judge Martinez interrupted, her voice cutting through the courtroom. The evidence you are referencing is not exculpatory. It has been reviewed and found inadmissible. I am ordering you to sit down, right now." Walsh remained standing. Blackburn, rather than attempting to calm the situation, stood up beside her in what appeared to be a gesture of solidarity. They were both on their feet, both arguing simultaneously, both ignoring direct judicial orders. Judge Martinez had seen enough. She turned to the bailiffs stationed at the sides of the courtroom. "Remove counsel from my courtroom." What followed was described by multiple observers as chaotic and virtually unprecedented in federal court. Bailiffs approached the defense table. According to reporters present, Blackburn and Walsh did not comply willingly. They continued arguing as officers reached them. Blackburn was still citing constitutional provisions as bailiffs took hold of his arms. Walsh was shouting that the removal would become grounds for appeal as she was escorted toward the exit.
The physical removal took several minutes because both attorneys resisted at every step. Blackburn's voice could be heard from the hallway, even after he was removed from the courtroom, still shouting about violations of due process. Walsh was yelling that Judge Martinez's actions would be overturned on appeal, and that the entire proceeding was illegitimate. Once the attorneys were removed, Judge Martinez sat in silence for a moment, visibly composing herself. Then she addressed the courtroom. "This court will take a 30-minute recess. When we return, I expect to see replacement counsel at the defense table, or Mr. Trump will proceed without representation for the remainder of this hearing." The shockwaves from that moment spread instantly. Within minutes, video and eyewitness accounts were circulating on social media. Legal analysts interrupted regular programming to discuss what had just happened. Former prosecutors and defense attorneys appeared on cable news, universally describing the scene as extraordinary and potentially career-ending for the ejected lawyers. The immediate legal consequences for Blackburn and Walsh are severe. Judge Martinez issued a written order later that same day, formally citing both attorneys for contempt of court. The order required them to appear at a show cause hearing to explain why they should not face sanctions. Potential sanctions include fines, suspension from practicing in that court, or referral to their state bar associations for disciplinary action. The order included full transcripts of the confrontation, leaving no ambiguity about what occurred. Blackburn's accusation that the court was a kangaroo court is documented verbatim. Walsh's refusal to comply with direct orders is recorded in detail. Their physical resistance to removal is described by multiple court officers in sworn statements. This isn't a he said, she said dispute. It's a fully documented record of contemptuous conduct. Legal ethics experts speaking to multiple news outlets emphasized that what Blackburn and Walsh did crosses clear professional boundaries. Lawyers can zealously advocate for clients. They can make aggressive arguments. They can preserve objections for the record. What they cannot do is accuse judges of corruption without evidence, refuse direct orders, and physically resist removal from the courtroom. The American Bar Association's model rules of professional conduct are explicit. Rule 3.5 prohibits conduct intended to disrupt a tribunal. Rule 8.2 prohibits making false statements about judges. Rule 3.3 requires candor toward the court. Blackburn and Walsh's conduct appears to violate all three. State bar associations that license attorneys take these violations seriously because courtroom order is fundamental to the legal system's functioning. Beyond the formal disciplinary proceedings, both attorneys face severe reputational damage. Legal careers are built on credibility with judges, opposing counsel, and clients. When attorneys are physically removed from courtrooms for contemptuous behavior, that credibility evaporates. Future judges will view them with skepticism. Future clients will question whether hiring them brings unnecessary risk. Future opponents will use this incident to impeach their credibility. For Trump, the consequences are equally severe. He now faces a choice: continue with attorneys who were just ejected from court,
or find replacement counsel immediately. Neither option is good. If Blackburn and Walsh return, Judge Martinez will be watching every move with zero tolerance for further misconduct. Any additional violations could result in criminal contempt charges, which carry potential jail time.
If Trump brings in new attorneys, they'll need time to prepare. They'll need to review thousands of pages of discovery, familiarize themselves with the procedural history, and develop a defense strategy. That takes weeks or months. The trial is scheduled to continue. Judge Martinez has already indicated she will not grant lengthy continuances for attorney changes that result from Trump's team's own misconduct. There's also the impact on Trump's public image. Defense attorneys being physically removed from a courtroom while shouting creates a visual that is devastating for any defendant. It signals desperation, lack of professional judgment, and inability to mount a credible legal defense. Jurors who might have been sympathetic to Trump will question why his lawyers resorted to such extreme tactics. The image of attorneys being dragged out by bailiffs becomes the story rather than whatever legal arguments they were trying to make. The show cause hearing for Blackburn and Walsh is scheduled for January 22nd, exactly 1 week after their removal. At that hearing, they must convince Judge Martinez why they should not face severe sanctions. They have limited options. Option 1. Apologize profusely, acknowledge their misconduct, and hope for leniency. This requires admitting they were wrong, which Trump rarely allows from anyone in his orbit. It also requires genuine contrition, which is difficult to fake in front of a federal judge who has spent decades evaluating witness credibility. Option 2. Double down and argue their conduct was justified zealous advocacy. This approach might appeal to Trump's base, but it virtually guarantees maximum sanctions from the court. Judges do not reward defiance with leniency. Arguing that accusing the court of corruption was appropriate conduct ensures the harshest possible consequences. Option 3. Blame Trump, claiming he pressured them to pursue tactics they knew were inappropriate. This saves their careers, but ends their representation of Trump and potentially exposes them to malpractice claims from their former client. Each option carries severe risks, but the clock is ticking. In 7 days, they face Judge Martinez again. This time, she's not presiding over a trial. She's sitting in judgment of their professional conduct. The power dynamic has shifted completely. They're no longer advocates. They're respondents facing potential discipline. Meanwhile, Trump's legal team is in chaos. According to sources close to the situation, Trump is furious about the ejection, but also recognizing that the visual of his lawyers being removed plays badly with potential jurors. He's reportedly scrambling to find replacement attorneys willing to take the case at this stage. The problem is that competent attorneys are watching what happened to Blackburn and Walsh. They're seeing 2 lawyers' careers potentially destroyed by representing Trump and following his preferred aggressive strategy. That makes recruiting quality replacement counsel extraordinarily difficult. Who wants to be the next attorney ejected from court or sanctioned by a federal judge? This pattern is familiar. Rudy Giuliani lost his law license in multiple states after representing Trump. Sidney Powell faced sanctions and criminal charges. John Eastman was disbarred. Alina Habba's representation in the E. Jean Carroll case resulted in an $83 million judgment. The roster of attorneys whose careers have been damaged or destroyed by representing Trump continues to grow. Legal recruiters speaking to news outlets report that Trump's team has been desperately reaching out to trial attorneys since the ejection. The response has been almost uniformly negative. One prominent defense attorney reportedly said, "There isn't enough money in the world." Another declined by saying, "I have a career to think about."
The January 22nd show cause hearing will determine whether Blackburn and Walsh face fines, suspension, or referral for disbarment proceedings. But regardless of the specific sanctions, the damage is done. They will be remembered as the attorneys who were physically removed from federal court for contemptuous conduct. That reputation follows lawyers for the rest of their careers. For Trump, the ejection represents a broader crisis in his legal strategy. He wants attorneys who will fight aggressively, create media spectacles, and prioritize loyalty over legal judgment. But federal courts don't reward that approach. They punish it. And when your attorneys are being dragged out of courtrooms by bailiffs, you're not demonstrating strength. You're demonstrating inability to mount a competent defense. The trial continues. Judge Martinez made clear that Trump's case will proceed regardless of whether he has counsel. If he cannot find replacement attorneys, he may be forced to represent himself, a prospect that terrifies even his supporters. Pro se representation in complex federal criminal cases almost never succeeds. Defendants don't know evidentiary rules, can't control their emotions under pressure, and make critical mistakes that guarantee conviction. 7 days remain until the show cause hearing. The trial resumes in 3 days. Trump needs new attorneys immediately, and the entire legal community is watching to see what happens to lawyers who cross the line from zealous advocacy into courtroom chaos. The message being sent is clear. There are boundaries that cannot be crossed, regardless of who your client is. And when you cross them, the consequences are swift, severe, and potentially career-ending.